If you weren't aware, the US Patent and Trademark Office grants hundreds of thousands of patents each year. In fact, the number of patents granted per year almost doubled since 1999. This has led the office to hire thousands more patent examiners, as there is still a backlog of over 1 million patents to get through. As you can imagine, given the number of patent applications and the limited number of examiners, speed can be an important factor in determining what gets accepted or rejected. Furthermore, especially in the realm of software and technology, examiners may not be aware of all the happenings in the IT world. This leads to a problem of obviousness, where a somewhat technical person like, say, myself, can go look at a patent and go, yeah, well, duh. Now, because of that, and because we are human, patents that should never have been granted in the first place may end up slipping through. At the same time these slip-ups happen, research from professors Michael Frakes and Melissa Wasserman earlier this year showed that the Patent and Trademark Office seems to have an affinity for granting patents in industries that would benefit the Patent Office, the most. Namely, software, information technology, data storage, communication technologies, and so on and so forth. These are industries with what we'd call frequent filers. Companies that apply for many, many patents. Businesses and other entities kind of went nuts at the turn of the century when the internet came into prominence. Suddenly, everything that was or could be patented could now be patented on a computer or on the internet. Yet somehow changing the location in which a patentable activity occurred became a significant innovation worthy of monopoly protections. How? I don't know. But this problem has existed for years, until recently. The Supreme Court in a unanimous 9-0 ruling last year concluded that merely doing something on a computer is not grounds for patentability. Seriously, when was the last time you heard of a unanimous ruling in the Supreme Court? That's how significant this was. Yet, the court did not conclude software shouldn't be patented. So even with this unanimous ruling, bad patents can still exist. And, of course, the more vague, the better. So let me give you some examples. Take patent number 42485, which deals with a method or apparatus for automatic vehicle location, collision notification, and synthetic voice. It was granted back in 1999, and basically it's GPS. So say you build an app that finds a retail location and gives you directions. We see these everywhere, do we not? Well, according to the owner of this patent, that's an infringement. All of the cases the owner has been involved in seem to have gone to settlement for nuisance sums, i.e. what a company is willing to pay to avoid the potential of a massive patent lawsuit defense. Now, consider patent 7986426. It's a patent that claims use of a scanner connected to a network is infringement. The owner, a company called MPHJ Technology Investments, has sent letters to thousands of companies demanding $1,000 for every employee that uses the scanner to copy and transmit documents over the internet, through email, or with other software. Prior art and obviousness be damned. These guys have been creating quite a stir. They've gotten referenced by Congress when Congress last considered changing patent legislation, by state attorney generals who are now getting involved, and thankfully MPHJ may finally have to defend its practices in court. But consider the damages already done. Consider the effect on startups and small business. How would you like it if someone had a patent that shouldn't have been granted in the first place, demanding $1,000 from you? Or worse still, $1,000 per employee from you? Considering the multi-million-dollar average patent defense, that might be your only choice, and it sucks. Now, finally, consider patent 8676045. It's a patent that was granted to Amazon in 2014 that covers photos taken against a white background. And seriously, it's a white background. So how could such a patent be granted? Well, simply put, Amazon was very, very specific in the distances involved in the photography. And because of our bad patent laws, merely offering up a distance ratio that did not appear in any instance of prior art became justification for allowing such an obvious patent to go through. It's a tragedy that something like distance in photography can really determine patentability in this day and age. Now, these are just a few examples amongst thousands upon thousands of bad patents. There are likely too many bad patents to actually count. I mean, a few years ago, researchers determined that the number of software patents being granted, coupled with the number of registered patent attorneys here in the US, meant it's mathematically impossible to not infringe on someone's patent. You would need over 2 million lawyers working full-time for a year in order to verify that your product does not infringe. And that's about 1.9 million more patent lawyers that are currently exist and billions of dollars that companies cannot afford. So hopefully all this information is enough to show you how bad patents can be. And I haven't even discussed medical patents, which possess their own unique challenges. The obviousness, vagueness, and abuse of patents hinders innovation and hurts companies, especially startups and small businesses who cannot afford to mount any real defense. The money to be made through intellectual property has resulted in our system going from the promotion of innovation to the promotion of profit, and we really need to change this. In the next and final video of the series, I'll tackle some of the changes we can make to curb intellectual property abuses. We must return to the notion that IP is meant for the progress of science and the useful arts. It's what our Constitution says and what we should embrace as a society. So with that, thank you very much for watching, and God bless you, and God bless the United States of America.